Good afternoon, viewers. Hope you all are sound and safe. Dear viewers, you all know that we broadcast this legal show, Law with Mahbub Toha, every Saturday, UK time at 5 o'clock in the afternoon and Europe time at 6 o'clock. We usually try to update you about all the latest laws, especially immigration laws. For this, we invite renowned personnel from law professionals to discuss on those immigration laws. Therefore, today we invited a special guest who is not only a lawyer but a human rights activist who is campaigning for the immigrants, especially those who are staying in the UK without proper documents. He is a public access barrister and head of Imperium Chambers, Mr. Paul Turner. You can find him on Twitter, Facebook with his continuous updates on immigration laws. You may watch his video blogs on YouTube as well, subscribing his channel, The Immigration Barrister. However, we want to introduce you all with our today's guest, Mr. Paul Turner. Welcome to our program. How are you today?
I'm very well. Thank you very much, Mahbub, for inviting me. It makes a nice change to be talking live rather than just recording programs. And hopefully some of the information will be useful. Now, I know we've discussed the matter before, so I thought I would break down what I was going to talk to into about 3 sections, and the reason for that is so that we get the best use of our time. Now, as has been rightly pointed out by one of the key issues that I'm involved in is pushing for an amnesty or an earned amnesty for people that are in the United Kingdom. Now, the Home Office, there's been quite a number of people that have signed up to the petition for an amnesty, and the Home Office initially responded by saying that they're not prepared to give one, that undocumented migrants can apply through the immigration rules. And the Petitions Committee said that that wasn't good enough, and that they had to provide a better response. Now, what they did was they then just rewrote the same response. Now, as regards an amnesty for people that are undocumented, there is an aversion in the UK to using the word amnesty. I've been doing this for over 20 years, and the government have always said, well, if we have an amnesty, that's just going to encourage more people to come to the United Kingdom. Now, whether that's true or not is completely undocumented. There's no statistics or evidence to show that's the case. Other European countries, in particular Portugal and lately Italy, have had an amnesty where they've allowed over 500,000 people to stay in Italy during the coronavirus pandemic, because it was the low-paid people that were picking the fruit, that were doing the care work, that were helping people out, that were A, at risk of contracting the illness, and B, without people picking the fruit or looking after elderly people, then the state just wouldn't survive. And so the government thanked the undocumented migrants and said, you can have a visa and stay. And that's what I've been pushing for in my videos, and been keeping updating people as to what the response is. I mean, we all know that Boris Johnson, when he was mayor of London, and I think when he was in government, said that an amnesty would be an excellent idea. Now, this would not be the first time that there has been an amnesty in the United Kingdom. It would be the first time it would be called an amnesty. For some people that have been in this field for quite a while, they'll understand that what there used to be, or what there was in the past, was something called the legacy scheme. And that meant that anyone that was a failed asylum seeker and had been in the United Kingdom for 6 years and wasn't a criminal could apply. And they did that because they had over 500,000 files that they couldn't process. And that led to over half the people, way over half the people that they actually had proper files on, being granted indefinite leave to remain. I think it was around about 200,000 people or so. And of those people, there hasn't been any scandal about them committing criminal offences, or there hasn't been any trouble or no huge backlash as to that. And the reason for the legacy scheme was that the Secretary of State for the Home Department at the time said that the entire immigration service, the Home Office, wasn't fit for purpose, that it just wasn't good enough. And the previous one got sacked, and this one brought in this new policy, and it ran for about 4 or 5 years. And overall, it was very successful. And I've had a number of clients that have come to me, and I've dealt with applications for them to bring over their spouses. I've had dealt with applications for them, other legal matters, and it all worked very, very well. There was a department set up for it. It was a very easy form to fill in. It worked so well that the government then started adding students that hadn't gone home, or people that had made family applications that hadn't gone home, and it took on a life of its own. And then they finally wrapped it up in about 2000, and it would have been 12, I think, or 13. But overall, I think it was a successful exercise. And it meant that a lot of people that were completely undocumented and were failed asylum seekers that had been here for 10, 15 years, as well as low as 6 years, were allowed to stay in the United Kingdom. So there is a precedent, there is a history of having what you could call a legacy scheme to deal with the old cases, or whether you could call it an amnesty, and I prefer to use that word, because the criteria for getting status was very, very low. So I continue to push for an amnesty, and the latest piece of material that I discovered was that the Public Accounts Committee, and I'll come back to that later when we talk about another subject, TOEIC and ETS. The Public Accounts Committee asked the Home Office whether what harm would be done if the million or so people that are here illegally were made legal. Would they cause problems in the future? Have they caused problems? Would they cause harm to the UK? And the Home Office response was that the vast majority would not cause problems. So it becomes harder to see why there isn't some form of legacy stroke amnesty or pardon for people that have been in the United Kingdom, given the fact that the Home Office accepts that the vast majority of people aren't going to ever cause any problems to the United Kingdom. Plus, there's the humanitarian aspect, which is that because of the hostile environment, people that are in the United Kingdom and don't have documents are frightened of going to the NHS, or frightened of going to the doctor, because they're frightened of being reported, or they're not allowed access to the NHS. And that, again, is a scandal in itself, because, as I say, we've all heard stories about people that have come over to the United Kingdom to work here and have contracted COVID and have died. So there is a very unfair situation. Now, the government says, well, we're going to introduce a new immigration policy, and the new immigration policy is going to be the points-based system, which is going to come into effect on the 31st of January next year, which is the same time that free movement within the EU ends. So that's an important date for people that have got EU connections to have regard to, which is the 31st of January 2021. And really, I would say that anyone that has any doubts as to their status in that respect seeks to deal with it before these changes come in, because this new system, this new points-based system that the government says is going to be fantastic, is basically the same points-based system that we've had before. Priti Patel has been saying that there's been a lot of changes to it. The only real change to it is that if you're in a shortage occupation, you can earn about 20-odd thousand pounds a year. But other than that, you have to earn £25,000 a year. But there are no other concessions. There's no bringing back the tier one entrepreneur visa. There's no other sort of general concessions, save for I think it'll be the middle of 2021. The government are going to go and bring back the post-study work visa. Now, I use the term post-study work visa because it's referred to now as the graduate route. Now, that, don't be confused, it is the PSW visa, which is that if you've graduated and you've got a degree, then you will be able to apply to work in the United Kingdom for a couple of years. And at the end of that, if you can find a sponsor or what have you, you'll be able to swap. So, but what the new points-based system doesn't do, and this touches on the amnesty, is it explicitly excludes low-paid workers, and it explicitly excludes healthcare assistants and people that work in healthcare homes. Now, around a sixth of the people that work in healthcare homes are migrants, and they earn around about between £16,000 and £18,000 a year. So they're not going to qualify. And what Priti Patel has said is, once their visa expires, then they'll have to apply under the new regime. And the new regime is going to be that you've got to be earning over £20,000 or £22,000 or £25,000 to stay in the United Kingdom. So January 2021 is going to be a major turning point for people that are in the United Kingdom lawfully but on a low wage. It's also going to mean the end of free movement. And in the policy statement that was announced, there is again this no mention of any earned amnesty. So pressure could be put on the government, and I hope it is, and I think other organisations are doing it as well, to introduce some sort of amnesty or probationary scheme or some legacy scheme so people can show that they are contributing to the United Kingdom. I think statistics have shown that migrants contribute more than they take out of the system. And anybody that's lived through COVID will know that it's often migrants that are on the front line, whether they're running shops or whether they're working in healthcare homes. I had someone recently come in to see me, and their entire family had contracted COVID because they had carried on working throughout the coronavirus pandemic. And rather than the person deciding to find another job, they'd gone back to their job. But according to the Secretary of State, there's no place for them in the United Kingdom after January 2021. So there is a need to keep up pressure on the government, primarily so that people can regularise their status, such as the Italians have done, or to put pressure on the points-based system to be more equal. I mean, when the government says points-based system, it's not a true points-based system such as the Australians have, where you can add things together, such as your age, your qualifications, your degree, and add all of these bits and pieces together. Because in the United Kingdom, the only factors that you can swap around are basically your salary and whether you're on the shortage occupation. So it's not as if you could say that you've got a PhD and that you're 19 years old and that you've got a number of children that could come here and that you're very well respected in your job and you've got glowing references. That won't get you any points at all. So one needs to be very, very careful about that. So that was the first topic I was going to talk about, which is that there is a need to keep the pressure on. There is a need to keep an eye, as I say, on this channel and on my channel to see what mistakes the Home Office make, because this can be used to put pressure on the government. I mean, one of the questions that I would like to ask Boris Johnson is, why did you change your mind? And not to have Priti Patel then just read me the immigration rules, because I can read them myself. I'd rather have him explain why he said, yes, an amnesty is an excellent idea. And I've put the part of the video in one of my videos where he says it is. I would say cynically, the reason why he said that was because he was standing as mayor in London, and London is probably, and it's one of the reasons why I love living here, it's one of the most ethnically diverse cities in the world, where it's a place where everybody gets together, mixes, and it's a joy to live in. And obviously saying, yes, there'll be an amnesty for people that are from abroad, it's a vote winner, or potentially a vote winner amongst the migrant community. But when it comes to the general election, and Prime Minister's looking at getting votes from Brexit anti-immigration constituencies, all of a sudden it all goes away. So I think if enough pressure was put on the government, they would look to do something about it. They are looking to make right the Windrush problem, which they've caused. And then one of the other points that I would put out is that in respect of Hong Kong, now it was well known that Hong Kong was going to be given back to the Chinese 30, 40 years ago. I mean, I remember it when they were having the discussions. There was no way we were going to fight over Hong Kong. And at that time, people from Hong Kong could have moved to the United Kingdom, but they chose to stay and were given a lesser form of citizenship, which was the British National's Overseas Passport. And now the government has said, well, because China has enacted these terrible laws, this up to 3 million people can apply for a passport and come and live in the United Kingdom. Now, with the greatest respect, people who watch the news or have any knowledge of history will know that China has an appalling human rights record. Its persecution of Muslims, it has been published and criticized, forcing millions of people into camps to re-educate them and take away their faith. So, and they've been executing people and killing people for far longer than 40 or 50 years. And now it seems to me that the government's saying, well, okay, well, you can all come over here now. And isn't that a humane gesture? Well, yes, it is. But it doesn't address the fact about the million people that are already in the United Kingdom, and the million people that are in the United Kingdom that are working, that are supporting not only themselves in the United Kingdom, and I've seen people living in quite desperate accommodation, but they're also remitting money back home and looking after families in countries less well developed, and often not seeing family members for 10, 15, 20 years. I mean, I've seen tragic cases where people just have never met their children because they are paying for their children by doing poorly paid jobs. And we've seen that with Boohoo in Leicester, essentially employing slaves. And really, it's just not, for me, it's manifestly unfair. Now that aspect of it is the general position. The second position is, what happens if you are an undocumented migrant and your leave expired, or for some reason you didn't renew your visa, and you're in hiding and you've been here for a long period of time? What I would say is,
I have one question from my viewer. He's been here for last 15 years. He came here as a student. After that, he made, I believe, 10, 12 applications. And then all applications has been refused. And then he applied for asylum, and which was also been refused. He's been here for 15 years. So what he can do now? He should wait for amnesty, or he can go for any kind of application. It can be human rights or any other application.
Knowing the immigration system and how slow it is, and if he's been here for 15 years, I would say that there are two main options that are open to him. One of the options would be either a fresh asylum claim, and the advantage of making a fresh asylum claim is that it won't cost any money. Secondly, it can take the Home Office a couple of years to deal with the fresh asylum claims. So, and if the person has new evidence and is granted a right of appeal, then again, there's I think a 38-week delay, or there was, in granting appeals. So if somebody came before an immigration judge with 18 or 19 years or 17, around about 18 years worth of residency in the United Kingdom, there are judges that if someone can show what they've done, that will allow the appeal, even though they haven't got to the 20-year mark. So there is that part. As to the human rights part, what I would say is, and one of the things that I will always say is, please see a lawyer. I mean, you're watching me on this excellent channel. Either of us, we are more than capable of advising you. I know Mahbub is extremely experienced in advising on whether you've got a claim. Now, it might be that you have health conditions. It might be that you have a wife that has health conditions. It might be that you have children that have been here for 5-6 years. And being very candid about it, whilst you might not meet the requirements of the immigration rules now, if you made an application with a 5.5-year-old child, by the time you end up before an immigration judge, or first two judges they like to call themselves now, by the time you end up before the court, you're going to end up with a child that is almost 7 or has crossed the 7-year threshold. So if you do have children, then that's a further factor. Then there are other factors. I mean, I've had people come to me and they say, I've got nothing. And then I've talked to them and it turns out that they've got severe mental health problems that have been brought on by living with lots of other people and living in fear for years, and they're suicidal. Now, that in itself can give rise to a human rights claim. So, and then I've had people that have had children that are 8 or 9, and for some reason, that because of a hostile environment, because of the news, they just haven't gone and sought any help at all. And there are cases that are very, very difficult, but for the person that's at 15 years, you're at 3/4 of the way through getting through the 20-year period, and you're faced with a Home Office that essentially isn't really making decisions very quickly at the moment, and an appeal system which again isn't making decisions very quickly, and you have a further right of appeal. So if someone's got over 15 years, then they really have two choices. One of which is to just say, well, actually, I've done enough, I'm going to go home. Or the other one is just to realize that the next 2, 3, 4 years are going to be a bit of a struggle, and engage with a good lawyer, because it may be that your previous lawyer didn't do a very good job. And then you've got, someone has 15 years, I would probably say that they've got an over 50% chance of remaining in the United Kingdom if they fight this and use the law, not illegally and not abusively, but they actually use the law and use the applications. Then, given how underfunded it is and given how poor it is, that they are likely to end up getting a visa in the end. If it was 12 or 13 years, I'd say it's probably just too much of a struggle. But if you've been here 15 years, you probably have established some form of private life, unless you're like one of the poor people I know that just work and send money home and don't do anything. But you may have a relationship with somebody that's an EU national. You may have a relationship with somebody that's British. Sometimes I have people that come to me and they say, well, I've got a partner and my partner's Polish, for example, but we don't want to get married until my immigration status is sorted out. And I would say, is the relationship genuine? And then if they say, yes, it's genuine, I'd say, look, get married. You don't get any bonus points by, and I might be speaking very candidly about this, you don't get any bonus points by coming to the United Kingdom, keeping your head down, and just working and avoiding immigration control. I've known many cases where people have come to the United Kingdom and the first thing they've done is find somebody that's British or is settled status, and then they've engaged in a relationship, had a child, and after 3 or 4 years, they end up with a visa. And it's heartbreaking when you end up with people that have manipulated the situation, got into a relationship with someone they don't really care about, had a child, and then they use the child to get status. And yet someone that's been here 14 years and has either no family, they haven't had the chance to get married, or they've got a family and they've been sending money home, and they're essentially punished and told that they're not wanted and they can go back. And so it's like shuffling cards. There are so many different factors. And as I say, for the person that's been here for 15 years, and if you've made an asylum claim, you've got the potential of a new asylum claim, you've got the potential of a human rights claim. The key thing you need to do is to go and see a proper lawyer and get proper advice. I mean, I could talk to you and tell you a variety of different case law and what they mean, but in reality, it boils down to length of residence in the United Kingdom, whether you've got a good reason to stay or whether it's unfair for you to be removed. So what I would say, before I move on to the third topic, which is probably there's a number of issues to cover, which will be TOEIC. I would say for the undocumented migrant, do make an appointment and do go and see a lawyer. Yes, it might cost you a small amount of money to do it, but if you see a reputable lawyer, you will know where you stand. And if the person says, look, you've got no hope, then at least you'll know, rather than making 5, 6, 7, 8 applications through dodgy lawyers. And as I say, I'm sure myself and Mr. Toha have seen lots of people that have come to us who've just been to one lawyer after another, who's just taken more money and more money and more money. And the only person that benefits is the lawyer and the Home Office. And all that happens is that the individual ends up with a very poor immigration history, because when they finally get a proper application put together, what happens is that they print out the refusal letter and it says, here are 15 reasons or 15 applications that you've made, and they haven't been successful. So before making any other applications or before doing anything, get to see the lawyer. Yes, it might cost you money, but it will save you a lot of money in the future. So that's dealing with, as I say, the first topic, which is, as I say, where we are with an amnesty. And the more people that put pressure on it, and I would say go and see your MP, speak to your MP about it.
Tara, is there any option to do something collectively? Because but there are a lot of people who are undocumented. So any option for doing something collectively? You are saying individual things like he or she needs to take lawyer's advice and he needs to go for proper applications. But as this channel is from Bengali community. So we know there are a lot of people who are struggling with this situation, so they can do anything collectively.
The answer to that is yes, if they are, and I'm happy to work with the Bengali community and with any other community, if we're able to put together a group of 3 or 4 people and then put pressure on MPs or MPs and councillors, and particularly I know there's a large Bengali community in East London, and there will be people that will have status and there will be people that don't have status, that are either related or they know each other. And so pressure could be, if a group could be put together, as I say, and I'll speak to you about that maybe during the week, and then we could form a small steering committee. And then, as I say, I've had contact with a number of MPs and a number of journalists. And at the moment, what you said is so right, is there's lots of different people all saying there should be an amnesty, there should be an amnesty. But what there needs to be is one group, so it speaks with one voice. So, and ideally, that needs to have a charity on board, and I can think of one charity that is particularly helpful, and following this broadcast and in the week I will speak to them, Migrant Voice, and then perhaps 1 or 2 solicitors, and then some politicians. And I think then it will gain its own momentum, especially given the fact that the 3 million Chinese are being invited over, and the problems with the Windrush showing up, that the fact that the Home Office are not, well, it's a scandal. And also there was another report that said that the hostile environment, the government doesn't know whether it works or it doesn't work. So yes, I think a group would be a good idea. And as I say, it's been my ambition to work with other people to do that. And that, so that I will keep you posted with. And as I say, if you're involved or interested in getting involved with, then that would be good, because it would be good to have 1 or 2 solicitors, a lawyer, a barrister such as myself, charity, and then to find an MP, preferably an MP who is dependent upon votes, if you like, from the Bengali community, because they'll be more interested in supporting it. So yes, I think something needs to be done in that respect, to rather than lots of different voices crying out, one voice speaking for everybody. So that's something that I'll certainly update everybody on, and I'll talk to you about what we can actually do practically. Perhaps we could arrange to meet with the MP and see whether the MP is interested in doing it, because if I was an MP and a large percentage of my votes were from a particular group, then yes, I would be interested. So I think that's an excellent idea, and I think that's something we can work on. So I think leaving that to one side, so or what we will do is we will speak, and we will identify 1 or 2 MPs and try and organise a meeting with them to put this forward and get them to see if they can drive it forward with the help of perhaps a charity as well, because there are more and more examples of Home Office incompetence coming out, and so there is, I would say, if there was enough pressure put on the Home Office, then yes, they would do something. And if you had to ask me when do I think it will happen, I think it will probably happen, and this isn't a great deal of comfort, but it will probably happen probably by around the middle of next year, when the new PBS comes in, and when we're outside of the EU, and then all of a sudden they discover that actually there is this huge labour shortage. And I think then would be the ideal time to actually say, right, rather than lowering the bar on new people from abroad, why don't we use the people from the UK? But there's nothing to stop us working on that now.
Okay, Paul, we want to move in our second topics, which is ILR refused due to TOEIC, because it's a burning issue. Lots of applicants are facing this problem, and they are suffering since 5-6 years.
Now, I've done lots and lots of appeals where people have been refused ILR on the basis of TOEIC. And the refusal letter usually says something along the lines of, well, in 2015, your leave was curtailed due to TOEIC, and then they've either, and then the group falls into two. Then there are the people that have done judicial reviews and lost, and then it went to the Court of Appeal, and then following Arsan, which is a well-known case that dealt with whether people could appeal in country, the Home Office agreed that those people could have an in-country right of appeal. Now, if you've been, your ILR application has been refused and you did go to the Court of Appeal, then you have an excellent chance of getting indefinite leave to remain, because the orders from the Court of Appeal will say that if it can be shown before a judge that you did not cheat, you should be put back into the position before the curtailment notice. So if your leave was curtailed in 2015 and you arrived in 2010, and then you go to court tomorrow and the judge says, well, obviously you can speak English, then what the judge should say is that and looking at the consent order, or looking at, if you've been to the Court of Appeal, they should say that the Home Office should put the person back into the same position they were before, which means that they would have leave, and if they have leave, then they should be allowed ILR, as long as they do the life in UK, and obviously they've passed the English language test because they've been proved not to have cheated. So those people, now there is a problem with that type of case, which is the representation, because the Home Office say, okay, so you didn't cheat, but you've only been here 10 years. And it is absolutely vital that you have a proper solicitor and representative who can highlight that what Arsan and what the Court of Appeal said was, if you had not cheated, you should be put back to where you were before the problem. And the Home Office have sort of issued guidance to that effect, but it's not very clear. And the Home Office presenting officers, and I've had it in a number of cases, even when the consent order from the Court of Appeal says put them back before the curtailment, so when they had leave, still say, oh, but they haven't had leave for the last 5 years. So it's really important that your solicitor and your lawyer at the appeal makes it clear that the only reason you don't have leave is because of the TOEIC allegation, and the TOEIC allegation was wrong. And so they have a difficult job, but they have a job that is easier to do. Now, the more difficult case is the person that didn't, for money, because judicial review is expensive, or they were scared, who didn't lodge the judicial review, and perhaps that their visa came to an end before, that if they apply for indefinite leave to remain and it's refused, again on the same basis, which is that the person had cheated in 2012 or 13, but that the curtailment was in 14 or 15, it is absolutely vital that it is pointed out that if they've been here for more than 10 years, and if the original decision to stop their leave was based upon ETS, and they've proved that they've not cheated, they should be allowed, the judge should say, I find they've been here 10 years lawfully. Now, if you haven't done the KOL life in the UK, then what I would say is do it as quickly as possible, or do it as soon as one gets the biometric permit, and then get the lawyer to write to the Home Office if they only give you 2 years, and explain the situation and ask them to upgrade it to indefinite leave to remain. So for that type of person, it's really they're in a more difficult position because they didn't go to the Court of Appeal, they didn't lodge a judicial review. So it will be necessary to explain why, and it may be money, it may have been pressure, it may have been fear, but it doesn't really matter. If you can prove that you didn't cheat, then the decision to curtail your leave is an unlawful decision, and therefore you've been living here and you've suffered for 5 years, 6 years, not being able to work, not being able to enjoy your life, and you will, if your case is put forward by a proper lawyer, a proper solicitor, then you will or you should get indefinite leave to remain. Now, that brings me really to how do you prove that ETS got it wrong when they sent out their sheets of information? Now, this is how I present appeals, and this is a formula which is entirely lawful, and it works. And there are 2 parts to winning getting your ILR if you've been refused to TOEIC. There are 2 parts to it. The first part is showing when you started to speak English. Now, there is no point putting in, you can put them in certificates 2-3 years after the TOEIC test, because the Home Office will say, well, you could have learnt English. It's ridiculous, but that's what they will say. So what I always say to clients is, when you did your secondary school examination back home, and then you did your higher secondary examination again back home, you would have probably done English. And if you did English, then you need to get those certificates, because those certificates will probably be 15 years old. They'll be very, very old certificates, and they will, or 10 years old, and they will show that you could speak English a long time ago. Another really important factor is, what school did you go to? If the school was an English medium school, and I know some families sent their children to church schools or English medium schools, then it's really important that you get a letter or you get evidence that shows that the school was an English medium school. Because if it was English medium, that means you started speaking English when you started going there at the age of 6 or 7 or maybe even 5. So you then have your letter from the school, you will have your secondary school exam, your higher secondary school secondary exam. You will also have probably done a course before coming to the United Kingdom in English. You will have probably had to do something you will have had to do, some people have done degrees, or some people have done a preliminary English course before coming to the United Kingdom. And often a lot of the TOEIC cases, people came in 2008 or 9. So if you can get those documents that go back to 2005 or 6, get those documents, then were you interviewed for the college when you came to the United Kingdom? Mention the interview. Then when you arrived in the United Kingdom in 2009, and before the government said you've got to get a new test certificate in 2011 or 12, what did you do during that period? Now, there are two things that people will have done. They would have done some more education. So it's really important to get whatever certificates, or if you couldn't complete the course, a CAS saying that you were accepted onto a particular course, and you get all of the evidence up to the TOEIC test. Now, some people were doing an MBA, and they passed the MBA 6 months after the TOEIC test, so, or a year after. So I would include that certificate, because there is no way you're going to go from not speaking English to getting an MBA 3 months after doing a TOEIC test. Now, that's really important. Now, there's also another factor that people miss. Lots of people came over here when they could, and they worked 20 hours a week. And I've seen this missed in many, many appeals. Now, a college might give you a certificate because they want the fee. But if you've been working in the United Kingdom for your 20 hours and during the holiday, then it's really, really important that what you get is you get some form of evidence of your employment. Because I've had people that have worked for McDonald's, so I've got the letter contract of employment, and then I've got their wage slips. And then when it comes to preparing the statement, I would say they could speak English 7 years before they came here. They worked for 3 or 4 years dealing, they had an English interview, working with English people. And then there's the curtailment. Now, that's the personal side of things. And obviously you need to have a good solicitor to work with to prepare this statement that shows that that not only did you get these certificates, but you also sat exams. So you would say, I sat the HSE, the SSE, I had to do an exam for this coursework, I had to do an exam for this. And the reason for that is because the Home Office will say, oh, well, you might have been able to speak English, but maybe you were a bit nervous of exams, so you paid somebody to do it. But if you can show that you've already been sitting exams for 6 or 7 years, you've been serving the public or working with the public for 3 or 4 years, then there is simply no reason why you would ruin your life by paying someone to sit the test for you. So that's the first part of it. The second part, which is the part that the lawyers do, is we put together the 3 reports that came out, which was the APPG report, which was the All-Party Parliamentary Group on ETS, the National Audit Office, who are responsible for making sure the government spends its money properly. And then there's another older committee called the Public Accounts Committee, and they also check to make sure that the government are doing their job properly. They conducted extensive investigations into the Home Office and ETS. The Home Office case is based entirely on what ETS told the Home Office. These reports will show clearly that ETS was or is a hopeless organisation. Where the Home Office says they're a $1 billion organisation, the world's biggest provider of English tests. That may be true, but the government set up a subsidiary, or not the government, ETS set up a subsidiary company in Holland called ETS BV, and they did that to avoid liability. Now, the government spent £21 million investigating ETS, and then they discovered that it was ETS that were in the wrong, because ETS couldn't tell them who cheated, in what circumstances people cheated. They're just unable to do it. I seem to have frozen. I'm not sure. But that's better. So they weren't, that they couldn't show who had cheated. They even said 8,000 people were British citizens who were migrants. So, and they had no way of checking the results that were sent from the college to ETS. There was no chain of evidence. Now, that's a criminal term, but if I was to, if someone alleges that something is stolen, you have to show where, and then it was recovered in somebody else's house. You have to show that the person owned it. You have to show that it was taken. Then when it's found in the person's house, you have to have somebody find it, a policeman. The policeman has to put it in a bag and put a date on it. And then he has to hand it to another policeman who puts a date on it. And then it becomes evidence. And then they use it in court. ETS doesn't have any of that. It has absolutely no real records. And one of the cases that I've been doing, where we got permission to go to the Court of Appeal, and it was due to be a test case, was based upon the fact that the Home Office knew ETS was not a good company, and they had serious doubts about the evidence that they put forward. The Home Office had a secret meeting and realised that the evidence wasn't good enough. When they went to court in SM Kadir and Arsan, they hid the evidence. So they pretended that ETS was fantastic. And so the tribunal, the court, thought, well, the government aren't going to be hiding information, so we can rely on the government. And then it turns out that actually the government's reliant, the government had kept information back, in my opinion. And so if that's right, that the government had kept information back, then it's arguable that the case of SM Kadir, which says that if they cancelled the test, it's your fault and you've got to prove you're innocent, that goes out the window. And then the burden is on the Home Office to prove that the person cheated completely. And that would be almost impossible in tests that were taken 8-9 years ago. Almost impossible. So there are these 3 reports, and there are lots of bits of information that your lawyer will take out of that and put into a skeleton argument. So for those people that have been refused to say ILR because of TOEIC, when you go to court, you have to show that you can speak English. Now, one of the difficulties, which I think some of the judges don't understand, is that before the curtailment, you may have had a job working in a bank, you may have had a job and you may have been studying for an MBA, and then all of a sudden you're not allowed to work, you're not allowed to study, and so you're then forced to live basically on charity. And what people tend to do is they look to their own community for support, and so they would then be speaking less English than they were speaking before. And so sometimes that can be a further factor that needs to be drawn to the attention of the judge, that for the last 5 years, this person hasn't been able to go out, get a job, interact with people. So really to win and to get your ILR, which if you haven't cheated, you're entitled to, as long as you've been here 10 years, it's the lawyer you choose. And as I say, Mahbub is an excellent lawyer, prepares the cases well. It's a lawyer that you choose who will get all of your old certificates, and then they will also get your employment record. Maybe you had a girlfriend whilst you were in the United Kingdom. Maybe you've still got the same girlfriend in the United Kingdom. And I've had cases where I've won in, where we've gone to call, and the person is, say, a Bangladeshi, and their girlfriend is from the Czech Republic. Now, they don't meet the EU requirements, but obviously he was such a charming chap that he managed to get this partner, and they got together, and they've been together, I think 5, 6, 7 years at the time. And she gave evidence, and so we had school certificates, work records, and then we've got the fact that he's got a relationship with somebody from that doesn't speak any Bengali. Now, he's not going to be able to get a partner if the partner doesn't understand the same language. And so these are the key factors. It's old certificates, it's any work before TOEIC, any relationships or friendships before TOEIC, and or about a year afterwards. And that would be your job with the lawyer to get that together. And then the lawyer then attacks the Home Office evidence. And if that happens and it's done properly, then you are going to win the appeal. Now, if you win the appeal, the Home Office should grant, subject to if you've done the Life in the UK test, they should grant you indefinite leave to remain. Sometimes they've given people 2.5 years. If they've given 2.5 years, the answer to that, again, is see your lawyer and go for what's called judicial review. And I've had a number of cases where people have won, they've proved their innocence, they've been here for over 10 years, they've got their life in the UK, they've got their English language, and then the government says, here's a 2.5 year visa. Well, they didn't apply for a 2.5 year visa, they applied for indefinite leave to remain. And so we've then gone and challenged the Home Office for not giving reasons and giving the wrong length of leave. And in those cases, I've also had a very good rate of success. And if you win your judicial review, you've got an excellent chance of getting your costs back. So trying to wrap all of that up into ILR refusal due to TOEIC, there are two groups. If you've got a consent order from the Court of Appeal, then make sure that your lawyer underlines the bit that says, if I win, I go back to the position before the curtailment. That means you will have continuous leave. If you didn't go for judicial review, then, and you make a new application and you say ILR was just wrong, then what you then do is you get the evidence that I've talked about and you put that evidence forward and make sure that you explain that the 2015 or 14 curtailment was unlawful, and that given that everybody else who has shown that it's unlawful, then you should be entitled to indefinite leave to remain. So they're the two groups of people. I've described the evidence that you need, and you need to work closely with your lawyer about it, because sometimes you might have certificates that you don't think are relevant. You might have done a nursing course, or you might have done a smaller course, but all of this will work in your favor. 3 years working somewhere for a British company. You didn't work for a British company speaking Bengali. You will have had to have been interviewed in English. You will have had to deal with people in English. And that's something that a judge will listen to and think, well, okay, the college might be a bit dodgy, but a bank isn't, or in my case recently, McDonald's, they're not going to employ someone that doesn't speak any English. They're not going to give them allow them access to the till and allow them to work. And often people work for 5 or 6 years. So that's also a relevant factor. And then finally, it's if you've had a relationship with somebody, even if you're not together and you're friends, perhaps they can write and say, yes, I was with this person. That's also a factor. So those three factors, coupled with the statement saying that you did an exam and sat an exam, you do that. The lawyers can do the rest in showing that ETS is hopeless, and you will win your appeal. You stand an excellent chance of winning an appeal. In the cases that I've done, which have gone and they've been planned like this, I've not lost a case where people have been able to produce this. Now, 4 years ago, after SM Kadir, and people had a harder job. Now, the judges are a lot more sympathetic. So as long as you do what the lawyer says and help the lawyer can help you to get your indefinite leave to remain, to which you're entitled to. So it can seem complicated, it can seem frightening, but that's why you need to use a proper lawyer. If you do that, they will guide you. They will hold your hand from the beginning until the end of the process. Now, I know if you've been, you've had bad lawyers for the last 5 years, they've told you to make EU applications or hopeless applications, then you must change your lawyer. You cannot be afforded to be connected to that lawyer. You've got to show that you've realised that that lawyer was wrong, and maybe there needs to even be a complaint made against the lawyer if they've been really, really bad. That will also show how honest you are, because you wouldn't be doing that if you thought that there was something wrong. So really, for people that have been refused ILR because of TOEIC, nowadays, the position could not be worse for the government as long as you follow the steps I've said, and as long as you stick closely to your solicitor, as long as you stick closely to Mahbub, as long as you stick closely to people that know what they're doing, then we will guide you through the process. And I think the final thing I would say on the subject is there is a reason why Mahbub has put this channel out. There is a reason why I'm talking to you. It is, we are qualified in dealing with immigration law. Immigration law is, this is not an advert, immigration law is massively complicated. There are more words in the immigration rules than there are, I think, in the Bible. It is so big that even the Court of Appeal judges have considered it to be really confusing and needs to be rewritten. Now, as I said earlier, the Home Office have no intention of doing that. They want to just keep plodding along and trying to deal with it, with this points-based system, and trying to take away people's rights of appeals. And I said that would be the last thing I would say. But finally, in any application, it is important that you talk about your human rights and not just TOEIC. So you can't just say, I didn't cheat at TOEIC, here are the qualifications, here's my work, here's my girlfriend, I didn't cheat at TOEIC. And the reason for that is that since 2014, appeals can only be allowed under protection, asylum, or humanitarian protection, or human rights. So you need to talk about your human rights, how you've suffered, what your life's been like, what level of integration you had in the United Kingdom before what you've been doing in the United Kingdom and how difficult it would be to relocate back home. The reason why I'm saying that, and I saved that to the end, is because if you do not bring up human rights, there is a chance the Home Office might say you haven't made a human rights claim and therefore you're not going to get an appeal. And that would be absolutely tragic, because if you get an appeal, you do what the lawyers tell you to do, then you are 7, 8, 9 months, maybe a year away from getting the ILR. And if it turns out that the process drags on and the Home Office finally give you ILR after you've been here for 12 years, you can apply to have a British nationality immediately, because there is provisions within the guidance that says if the Home Office make the wrong decision and that delays your grant of ILR, you don't have to wait a year before you can apply for a British passport, which is Section 6.1 of the British Nationality Act 1981. That's a side issue, and that would hopefully be for people once they've got their ILR, in that they don't have to wait a year. But the short answer is, do what I've suggested, do what Mahbub suggests, listen to us, do what we say. It might seem like we're asking you to do an awful lot of work, but the more you do, and you have the information, if you give it to us, we can make it into a case. If you don't give it to us, it's going to be very difficult. I hope I've said things that are useful and helpful, and I think I hope I haven't gone on for too long. Over to you, Mahbub. I mean, is there anything particular?
Thank you, Mr. Turner. I have one question for you, which I received from the viewer. He asked, he came here in 2010 as a student, and then his visa was curtailed in 2015, and then he appealed against that decision, which was exhausted. His appeal right was exhausted in 2018. After that, he made set O application. That application also was refused by the Home Office. So what he can do? Would you advise the same, or that there is different advice for him?
For him, what I would say is he needs to get to your office as quickly as possible and show what documents were submitted, because I've seen cases where people didn't submit the right documents, or they only submitted a couple of documents. So I would say that somebody in your position, where you have lost the appeal years ago, but where you didn't put in all the evidence, you should make a further application. If you've got new evidence, such as work, you probably didn't think about work, and yet most people I know worked here when they got here. As soon as they got here, they worked for 20 hours a week. If you can put in that new evidence, and then you put in the material relating to the APPG, NAO, PAC, then you should get a further right of appeal. So it sounds like your case was not properly dealt with.
Yes. Okay. Mr. Paul, though our program is for 1 hour, we have already passed this one. I believe it will be very helpful for our viewers. You discussed in details about the amnesty for undocumented migrants and the ILR refusal due to TOEIC. I think our viewers may have some questions, and they usually do it later on through the text or through the comment in our Facebook page. If we got something, then we will try to answer, and we will try to come back to you. Thank you very much for giving us time, and I believe it was really, really helpful for our viewers.
Thank you very much for asking me. And as I would say is, as Mahbub said, any questions, put them in email. I'm sure Mahbub can answer them. If he wants my opinion, then I'll quite happily give my advice and what have you in that respect to anyone that's watched, anyone that's participated. So please don't feel like you're on your own. We are here to help, and we will do everything we can to help you. But thank you again, Mahbub, for inviting me. It's been an absolute pleasure.
Thank you very much.
Stay safe, and to everybody else, stay safe, and let's hope that life returns to normal soon.
Thank you. You too.
Thank you.
দেশি খাবার, গ্রিল, ফাস্টফুড, হালিম এবং বিরিয়ানি সহ যাবতীয় সুস্বাদু খাবারের জন্য মক্কা গ্রিল। আমরা শতভাগ এইচএমসি অ্যাপ্রুভড হালাল মাংস ব্যবহার করে থাকি। আমাদের আছে প্রায় 70 সিটিং ক্যাপাসিটির হল রুম। মহিলা, ডিসেবল এবং ফ্যামিলির জন্য রয়েছে আলাদা বসার ব্যবস্থা এবং টয়লেট ফ্যাসিলিটিস। আমরা জন্মদিন, বিয়ে সহ যাবতীয় অনুষ্ঠানে খাবারও সাপ্লাই দিয়ে থাকি। ইসলাম মসজিদের পাশে মক্কা গ্রিল, 110 হোয়াইট চ্যাপেল রোড, T1 আপনার অর্ডার কিংবা বুকিং এর জন্য ফোন করুন 0207375331 মক্কা গ্রিল।